Good day and thank you for watching. If you already have a family court order in California, whether it involves child custody, visitation, child support, or spousal support, you need to understand something very important. That order is not necessarily permanent, but changing it is not automatic. Many people assume that if their situation changes, the court will simply update the order. That is not how it works. To modify a court order in California, you must show what the law calls a material change in circumstances. And that standard truly matters. Let's break this down in detail. A material change in circumstances means that something significant has changed since the last court order was made. Not minor changes and not temporary inconveniences, but real substantial changes that affect the existing order. For example, in a custody case, a material change could include a parent relocating, a change in a child's needs, or concerns about a child's safety or well-being. In a support case, it could involve a significant increase or decrease in income, a job loss, or changes in financial responsibilities. Here's where many people make a mistake. They assume that because their situation feels different, the court will agree. But the court is not looking at how you feel. The court is looking at whether the change is significant enough to justify modifying an existing order, and more importantly, whether that change affects the best interest of the child or the fairness of the financial arrangement. Now let's talk about timing. Another common mistake is waiting too long to take action. If your circumstances have changed, but you continue to follow an outdated order, that can create problems. For example, if your income decreases and you continue to pay the same level of support without seeking modification, those payments may still be legally required. The court does not automatically adjust obligations. You have to request the change. On the other hand, acting too quickly without proper preparation can also hurt your case. This is not just about filing paperwork. It's about presenting a clear, well-supported argument backed by evidence. That brings us to documentation. If you are seeking to modify a court order, you need to support your claim with evidence. That may include financial records, employment information, school records, medical documentation, or any other relevant information depending on the issue. Without proper documentation, your request may not succeed. Family law cases are not decided based on assumptions. They are decided based on what can be proven. Now let's focus specifically on child custody. In custody modifications, the court's primary concern is always the best interest of the child. That standard does not change. But what can change are the circumstances surrounding the child's life. For example, if one parent's living situation becomes unstable, or if there are concerns about the child's safety, those factors may support a modification. But again, you must prove it. The court is not going to make changes based on speculation. The same principle applies to visitation schedules. Changes in work schedules, school needs, or the child's routine may justify an adjustment, but only if it can be clearly demonstrated. Now let's turn to support. Child support and spousal support can also be modified, but again, the key is demonstrating a material change in circumstances. For child support, the calculation is based on a formula. If income or custody time changes significantly, that may justify a modification. For spousal support, the court considers multiple factors, including the length of the marriage, earning capacity, and financial needs. But even here, the court expects a clear showing of change. Now let's address another important point: strategy. Modifying a court order is not just about asking for a change. It's about how you present your case. You need to anticipate what the other side may argue. You need to understand how the court will evaluate your request. And you need to be prepared to support your position with evidence and clear reasoning. This is where many people fall short. They focus only on what they want to change, without fully understanding how the court will analyze the situation. Family law is not just reactive, it's strategic. Finally, let's talk about expectations. Even when there is a valid basis for modification, the outcome is not guaranteed. The court has total discretion. That means the judge will evaluate the facts, consider the law, and make a decision based on what they believe is appropriate. That is why preparation, documentation, and timing are all critical. In conclusion, modifying a family court order in California requires more than just a request. It requires a clear showing of a material change in circumstances, supported by evidence and presented strategically. If your situation has changed, you need to take the right steps and take them at the right time. because waiting, guessing, or acting without preparation can affect your case in ways that are difficult to correct later. If you're dealing with an existing court order and believe a modification may be necessary, take the time to understand your position and your options. Call us at 888-888-6582. I'm Vince Davis, and we are all in this together.